Chapter 7, Property Law. In the previous chapter, we talked about intellectual property. Much of property law also applies to intellectual property, even if you cannot necessarily touch it. In this chapter, we're going to talk about the differences between title and possession. We'll also talk about the differences between real property and personal property. And we'll close with a little bit of landlord-tenant law, which likely applies to many of your lives. Different types of property. There are two major types of property: real property and personal property. Real property is land and the things attached to the land. This is why you purchase property from a real estate agent. They work with real property. Real property can include land, houses, mineral rights, and even air rights. Personal property is property that is movable. Most personal property is tangible, like a car, television, or furniture. But personal property can also be intangible, like stocks or intellectual property. Title and possession. When talking about property, it is important to differentiate between title and possession. Title is the intangible legal ownership right to the property, whether real property or personal property. Possession is the physical control of the property. If you're borrowing your friend's lawnmower for the weekend, you have possession of the lawnmower, but the lawnmower is not yours. It still belongs to your friend. When you purchase a car, the title is with the bank, but possession is with you. The bank is who really owns the car. They have the title. You're just paying off the bank. Once you've paid off the loan, the bank will send you the title, and now you have both title and possession. Knowing the distinction between title and possession is important as it affects how the court addresses property disputes. Laws that relate to personal property. In this section, we're going to discuss some unique laws affecting personal property. We'll talk about misplaced or lost property, the different types of ways property can be gifted, and the law affecting bailments. These can all have a serious impact on your business and its rights and responsibilities. As we talk about these things, consider the difference between title and possession and how they fit in. Misplaced personal property. Property that has been misplaced is treated differently depending on if the property has been lost or abandoned. If property has been abandoned, then the person with the title immediately forfeits it. They've decided that they no longer want that item. Property can only be legally abandoned if you have title. You couldn't disclaim ownership of something you simply possess but belongs to another. The law in this case is quite literally finders keepers. Or, as we say in the military, gear adrift is gear a gift. Better still is gear adrift is gear for griff. The first person who decides to stake a claim on the item is granted title and it becomes theirs. The only exception to this is if the property is abandoned on another person's real property. In this case, the owner of the real property can claim title first. If they do not claim title, then the law reverts to the first person to stake a claim being granted title. If property is simply lost or forgotten about and left behind, the law requires a few additional steps. A person who has lost or forgotten something has not relinquished title. They still want to own the personal property. If you find that lost property, you do not suddenly have title over it, since title still belongs to the owner. Instead, you are first in line to claiming title over it should it not be recovered by its rightful owner. Every jurisdiction has its own set of rules related to this, but most of them have similar requirements. You have possession, but not title, and must file some sort of notice that you have the property. In some places, this could require taking it to the police station for holding, or to your school's lost and found. In other places, a public notice must be placed in the paper, and in others, something like a note where the item was found will suffice. If the person with title shows and asks about it, but you pretend you don't have it or otherwise lie, you are committing theft by denying someone access to their own property. After notice has been posted, the clock starts running for the title holder to claim the item. Jurisdictions vary wildly on this, but 1 to 6 months is common. If the title holder does not claim the property within that period, then you have now cleared title. The property is now yours since you have both title and possession. Once you've cleared title, if the original owner were eventually to show and demand the item back, you wouldn't have to return it. You have title. If he takes it back, he has committed theft. Gifts. Giving a gift seems simple. You give the gift, it's over. But that's not necessarily always the case. I'm sure we've all had some experience, especially when we were younger and less mature, where someone attempts to take back a gift that they've given. Well, gifts can also be classified in several ways, each of which are affected by their own laws. Gifts inter vivos. Gifts inter vivos, or gifts between the living, are our standard idea of gift giving. Gifts inter vivos require 3 elements to be valid: intent, delivery, and acceptance. The giver must intend to give the gift. Vladimir Putin is famous for asking to see something from people and then saying, "Spasiba za padarak." Padarak, I don't know, pardon my Russian. And simply keeping it and thanking the person for the gift. This is theft, and Putin does this as a power move. It is not a valid gift because the giver did not intend to give title to that item. But it's Putin, so what are you going to do? Title to the item must be delivered. Delivering possession alongside title is ideal, but that's not always practical depending on the item. So delivering title is sufficient. You can deliver title in any number of ways. You can deliver possession and tell the person it's theirs. You can simply email or tell a person you're giving them something. You can call someone on the phone and tell them to come grab it off your doorstep. Delivery in this sense is the same as when you legally communicate an offer or acceptance in contract law. You're simply giving over and clearly communicating title, legal ownership of that property. The last element required is the recipient of the gift must accept it. Acceptance is legally presumed. The recipient doesn't have to literally say, "I accept," for the gift to be valid. They're getting something for nothing, so the legal presumption is that there is an acceptance. However, the recipient can refuse to accept the gift if they want. This simply means you cannot force a gift on another person. I'm sure we all know that person who re-gifts items or tries to give away things they don't want anymore. Well, if you don't want it and they try to gift it to you anyways, you can simply refuse the gift and title will not change hands. Gifts causa mortis. Gifts causa mortis are gifts because of death. These are similar to transfers of property in a will because the gift giver says you can have the property if I die. Unlike gifts inter vivos, this is a revocable gift. With a gift inter vivos, once the elements are met, title changes hands and there is no obligation of the recipient to return the gift if demanded by the giver. There are 3 scenarios where a gift causa mortis may be revoked. The first scenario is if the gift giver doesn't die. This is the entire point of a gift causa mortis. The gift is given if I die. If she doesn't die, then the condition of death hasn't been met and the gift is revoked. The second scenario is if the giver revokes before death. The condition of giving the gift is her death. This is similar to how in contract law the offeror can revoke the offer prior to acceptance. The gift can be revoked prior to the condition of death being met. Lastly, if the recipient of the gift dies prior to the giver, then the offer is revoked. The gift does not go to the estate of the intended recipient. Conditional gifts. The last type of gift we're going to talk about are conditional gifts. There are many ways a conditional gift can be set up. Some will look like a defeasible estate, which we will discuss shortly when we cover real property. Others will look almost like a contract. What is important is the specific way the condition on the gift is set. It is important that conditions are made very clear to avoid legal problems moving forward. An example of a conditional gift might be a parent gifting a car to an adult child. The parent might say, "I'm giving you this car upon the condition that you never vape again." Seriously though, stop it. In 20 years, people are going to be crying to Congress and in the courts, acting like they didn't know vaping was bad for you, and you're going to look just as stupid as those smokers you see today saying they didn't know smoking was bad. Plus, you look dumb. Besides, how pathetic is it to be addicted to the little nicotine in your little stick? In this case, the parent is giving the car to the child, but the gift is revoked and the car is never required to be given if the child vapes. If the child already has the car, depending on how the condition is worded and applicable case law, they might even have to return it. In our second example, the parent says, "I'm giving you this car upon the condition that you get a 4.0 grade point average in college. You aren't granted title to the car until the condition is met. But once it is met, you graduate with a 4.0 GPA, then the car is yours and it cannot be revoked. This is like a contract with the elements of offer, acceptance, and consideration. The only real difference is that in this case, the element of consideration does not exist. There is a condition, but it doesn't have to be something of legal value, nor does the doctrine of mutuality exist. Remember, in contract law, under the doctrine of mutuality, each side gains consideration and each side loses consideration. In this case, the child getting a 4.0 GPA has no legal value, and it doesn't really profit the parent, but it is still a condition that must be met. It's very important to make your conditions clear when giving a conditional gift. Ambiguous conditions can cause a lot of conflict that may end up in court. A common area of conflict are engagement rings. When an engagement ring is given, it is often after someone answers yes to, "Will you marry me?" But if the wedding is broken off, the question of whether or not the condition is met becomes ambiguous. What is the condition attached to the ring? Is the condition that you will agree to marry and get engaged? Or is the condition that the wedding must actually happen? Or, as is the case in many jurisdictions, is an engagement ring simply a gift inter vivos instead of a conditional gift? Many, but not all courts have taken this approach simply because determining the condition of an engagement ring is just too difficult. If a parent says they'll buy a car for an adult child if you stop vaping, is the condition met when the child stops vaping? Or is the condition always in place, and if the child takes a single hit of a vape pen 10 years later, then the gift is revoked? This sort of thing is likely to end up in court where the reasonable person standard will apply unless the conditions are made clear prior to giving the gift. Bailments. Bailments occur when a person, the bailor, grants possession but not title to another person, the bailee. When you take your car to the mechanic, you have created a bailment. You have given possession of your car to the mechanic, but you've certainly not given them title. If your friend permits you to borrow his lawnmower, you've been granted possession but not title. You don't own the mower. For a proper bailment, 3 elements must exist. The bailor must have title to the property. The bailor must deliver possession but not title. And the bailee must be aware of the terms of the bailment, the property that is changing hands, particularly their duty to return the bailment. To the first element, a person cannot grant you possession of property they don't own unless they're an agent for the property who does own it. Recall that someone with express or implied authority may make legal decisions for another, such as granting possession of property that person holds title to. I cannot tell you that you can borrow my neighbor's car. It isn't my car. But if I'm a partner in a partnership, I can grant you possession to the partnership's property. Possession must be legally communicated to the bailee. In most cases, that means you're physically delivering possession, such as when you take your car to the mechanic. But, like with a gift, delivery of possession only means that you must legally communicate the right to possess. If my friend comes over and asks to borrow my lawnmower, and I say, "Sure, you can get it out of my garage," then I haven't physically delivered the mower, but I have delivered my permission for them to borrow it. Lastly, the bailee must be made aware that this is not a gift. They must know what the terms of the bailment are. What are the expectations? When do you expect them to bring the car back? Do you expect them to return it with a full tank of gas? Are they expected to pay you to borrow it? Each party to the bailment owes each other specific duties. These duties should be spelled out prior to the creation of the bailment. But there are some implied duties each side has. That duty largely depends on who benefits from the bailment. If you ask to borrow my truck to move, then you, the bailee, are benefiting from the bailment. Your duty is to return the truck to me. Your duty is also to use reasonable care not to damage my truck. If you borrow something of mine, but it comes back damaged, then you're going to be legally presumed to be at fault. You can challenge this in court if someone else is actually responsible, but absent any other evidence, you'll be considered at fault for the damage. If I ask you to watch my dog for a week, then I, the bailor, am benefiting. That means I have certain duties to you. Those duties include warning you about any medical issues my dog has. If my dog bites or jumps fences, I need to let you know. I also need to provide you the dog's food or pay you for any food you spend on him. In many cases, the bailment benefits both parties. This is what happens when you rent equipment from a store or when you take your car to the mechanic. Both sides are getting a benefit. The duties associated with this are for the bailee, the mechanic, to take reasonable care of the property and to return it. Any additional duties should be attached to the contract between the parties. The most important duty in a bailment is the bailee's duty to return. Remember, with a bailment, title remains with the bailor, so she still owns it. Possession is only being granted temporarily to the bailee. In some cases, the bailee may seek out a lien from the court. Liens are a sort of encumbrance or ownership interest placed upon another's property. A common type of lien is what's called a mechanic's lien. This sort of lien attaches to property when someone performs labor on that property. If a person comes to your property and builds you a shed, they have an ownership interest in the shed until they've been paid for their work. In bailment law, this may affect parties so that a bailee who performs labor on something, such as a mechanic working on a vehicle, may refuse to return the bailment until they have been rightly paid for their labor. Laws that relate to real property. When talking about real property, we're discussing land and those things attached to land. This includes what the different types of ownership interests are, as well as ways for multiple people to own property. We'll also discuss restrictions on your own right to own or use your own property, along with how property rights are transferred. Possessory interest in land. There are 3 different ways a person may have an ownership interest in a piece of land. What is important when talking about real property ownership interest is that there are people with present interests in the property and there are people with future interests in the property. Sometimes those with present ownership interests also have future interests. Sometimes they're separate. The first and most common is referred to as fee simple. The terms fee simple absolute, fee simple, fee absolute, or just fee are also used interchangeably. This means that you own the property outright, subject to any encumbrances upon it. We'll talk about those later. You own the property and you have the right to possess it. You have the right to determine who is allowed on the property. And when you die, you have the right to dispose of that property how you see fit. A person who owns property in fee simple has all of the present and future interests in that property. Next are defeasible estates. If your ownership interest is in fee simple, then you own the property and you have the right to possess it. With a defeasible estate, you can lose that right of possession. With this type of ownership, there is some condition placed upon the property that, if triggered, will cause the person with the present interest to lose that property. The property will either go back to the person who transferred it to you, called a reversion, or it will go to a third party with a future interest in the property, called a remainder. An example of this would look as follows. B-Law Estates is being transferred to student A so long as she uses it as an animal sanctuary. Otherwise, it goes to student B. In this case, student A has a defeasible estate. They have a present possessory interest in the property. Student B has a future interest in the property. Student B's future interest becomes a present interest if ever student A no longer uses B-Law Estates as an animal sanctuary. If no other person out there has a future interest, she then owns the property in fee simple. Defeasible estates happen commonly, but are not limited to charitable giving when a person wants to ensure specific conditions are attached to the property. Next are life estates. A life estate provides the person with the present possessory interest in the property, the right to live there or use the property for their natural life. Upon their death, the person with the future interest in the property is granted ownership over the property. These present and future interests can become very complex and often end up in the court system. A common example of this is when a defeasible estate is granted, and after several decades, the present interest holder loses track of the fact that there are conditions to be met. Forgetting that it's a defeasible estate, they violate those conditions, and the property is set to go to the person with a future interest. Or a future interest holder arrives laying claim to the property because of disagreement over whether the triggering conditions are met. These future interests can be sold and stacked. The property goes to A, then B, then C, for example. This is limited only by the rule against perpetuities, a rule entirely too complex for this book and much feared in law schools for its complexity. The rule is designed as a limit on a person's ability to control property too far into the future. Types of ownership. Property is sometimes purchased by more than one person. The most common ways that several people hold property together is as tenants in common or as joint tenants. Tenants in common each have a divided interest in the property with no right of survivorship. Let's say that you purchase a property with 3 other people. Each of you own your own portion of the property, 25% each, or any other distribution in which you have all entered into with your agreement. Each of you have the right to sell your own 25% interest to whomever you wish. You can take out a loan and attach 25% of the property as collateral. When you die, your interest goes to whomever will receive your estate. Even though you have a divided interest in the property, you will have full possession and access to the property. Most property owned by multiple people is owned as a joint tenancy. In a joint tenancy, each person has an undivided interest in the property. If the 4 of you have purchased the same property as joint tenants, then each of you have ownership over 100% of the property. Each of you has the power to sell, take out a loan against, or otherwise behave as an agent for all legal matters with the property. Most joint tenancies also come with the right of survivorship. This means that if one of the joint tenants dies, instead of their interest going to their estate, it goes to the other joint tenants. If there are 4 joint tenants, each with 100% ownership, when one dies, there are 3 joint tenants, each with 100% ownership. When one of them dies, there become 2 joint tenants, and so on. While this sounds unreasonable for most applications, it's the most common form of ownership because most homes are purchased by married people. When a spouse dies, their interest simply goes to the other spouse. Non-possessory interest in land. It is possible to have a right to use land that you do not own. It's common for us to want to access land or have some interest in what happens in property that we do not necessarily own or possess. As we will see, this includes both your ability to access another person's land, as well as your interest in limiting what other people do with their own land. Easements. An easement is an access interest to part of another person's land. This can include the need to physically enter and travel over another's land, or to place things on, above, or under another's property. A common version of this is a utility easement. Sometimes the city orders that a portion of your property, most of the time 3 to 5 feet from the sidewalk, be accessible to utility companies to bury lines. This often affects local ordinances about where people are allowed to place their fences. But if the city doesn't already grant it by law, sometimes the utility company or someone else will have to pay you for any easement. An easement not only allows someone else access to your land, but it also prevents you from doing things that you want with your own land. If a person has an easement to drive across your property to get to their home, you would not be able to gate that area off or block the easement. If the cable company purchased an easement to trench some line under your property, then you'd be unable to dig to put a swimming pool there. Profits and licenses. A profit is a non-possessory interest granting access to your property to retrieve mineral or other natural resources. Perhaps you have several wooded acres. The local lumber company pays you for a grant to come onto your property and cut down trees. They're a lumber company, so they don't want your land. They just want the trees on your land. The land is of no value to them once the trees are gone. Maybe you live in an area that has a lot of deer and a hunter wants to come onto your property to hunt some animals. Or maybe you have oil on your land that would interest petroleum companies. A license is a grant of permission to use your land for a short-term specified purpose. Without a license, entering onto another's property would be trespassing. Some licenses are express licenses. A person asks to come onto your property to go camping. You give them explicit permission, license, to come onto your property. But most of the time, a license is an implied license. Consider when you go to the store. You neither own the store nor the real property that the store is on. But there's an implied license for you to come onto the store's property. How else would you shop there? While there's an implied license, that license can be revoked. If a person is caught shoplifting, the store might have them trespassed. This simply means that their license has been revoked and they are no longer allowed access to the property. You invite some friends to come over and drink beers and watch some fights on TV. They're coming onto your property with your permission. You've given them a license. Restrictive covenants. Restrictive covenants are limitations on what you can do with your own land. They're another form of non-possessory interest. Perhaps your neighbor is upset that you like to have bonfire parties during the summer, causing smoke to waft onto their property. They might pay you not to do so. Most commonly, we see restrictive covenants in residential areas covered by homeowners associations, HOAs. These commies like to attach some absurd restrictive covenants onto property to make a clean and flavorless neighborhood in order to preserve quiet and enhance property values. Restrictive covenants may be either positive or negative. A positive covenant is something that you must do. You must keep a green lawn. You must hang Christmas lights during December. You must have a little white picket fence and keep it maintained. You must keep your garage door closed at night. A negative covenant is something that you must not do. You cannot have a flag flying on your property. You cannot leave a car in your driveway. You cannot work on your car or change the oil on your property. You cannot butcher a deer you've killed over hunting season. You cannot shoot air rifles in your backyard. These encumbrances often run with the land. This means that if you transfer property to another person, they are getting the land along with these restrictions. The new owner cannot arrive and suddenly block off an easement or build a giant flagpole on the property by arguing that they weren't the ones who made the deal in the first place. It's like when two corporations merge. They purchase not only the assets, but also the liabilities. So too with encumbrances on land. You've purchased the land and the restrictions placed on the land at the time of sale. The bottom line is that you need to be aware of what exactly it is that you're purchasing. And if you're unhappy with silly rules, don't purchase a home with an HOA. In many instances, an HOA can fine homeowners who do not comply with their rules, and sometimes these disputes end up in court. Zoning and environmental law. There may also be zoning laws dictating what can be done on your property. Zoning laws are often established by the city or county. These are put in place so the city can be built in a logical and consistent way. Most cities have zoning laws ensuring that industrial areas, commercial areas, and residential areas all remain separate. Most cities wouldn't want a chemical plant next door to a residential area where children play. Zoning laws ensure that adult theaters or drug and alcohol stores are far away from schools. Environmental laws may also be positive or negative. A positive environmental law might require that a business use water-saving tools. It might require a gas station have procedures in place to deal with oil spills. A negative environmental law might dictate what you're allowed to pour down your drain. It might limit the types of pesticides a farmer uses. Transferring real property. When transferring any property interest, you need to be clear what is and what isn't being transferred. You need to understand the nature of the transfer. Is it future interest or present interest? Is it a possessory or non-possessory interest? Is it ownership as tenants in common or as joint tenants? Are you getting the property outright or does it have any encumbrances on it? Once you've figured out exactly what you think you're transferring, there's the process of ensuring clean title passes and your deed is properly recorded. We'll cover all of that next. Deeds and title. When property changes hands, it is done so through a deed. The deed is the physical document memorializing the transaction. The point of the deed is to show a transfer of title. Just like with personal property, title isn't something tangible. Title is simply the invisible legal ownership right. The two major types of deeds we're going to cover are quitclaim deeds and warranty deeds. A quitclaim deed is exactly what it sounds like. It is a deed quitting any claim a person has on the property. Quitclaim deeds are most common when you have joint tenants with right of survivorship. A couple might divorce, leaving the property to the former partner. They would quit their claim on the property, leaving it solely in the hands of the other person. A person should be very cautious when purchasing property through a quitclaim deed. This is because there are no guarantees against any defects in title. A person is literally quitting their claim on the property. I can sell you a quitclaim deed on my neighbor's property. What have I sold you? Nothing. I have no claim on their property, and I have now sold you what I had. Nothing. It is not unusual for there to be defects in title or other encumbrances on the property that a person doesn't necessarily even know about. With a quitclaim deed, you may well believe you're purchasing something different from what you in fact have. Warranty deed. A warranty deed has guarantees assuring you clear title to what you have purchased. Warranty deeds may be a general warranty deed that warrants against all defects in title, or a special warranty deed that only warrants against specific defects in title. If a property changes hands and there is a defect in the title, the seller would be required to make that right, either by compensating you financially or paying the other person to clear title for you. Perhaps a future interest holder arrives, and you discover that this was a defeasible estate instead of fee simple, and someone else actually owns the property. Or there's an easement on the property that was unknown to everyone until the easement owner shows up to exercise his right. With a warranty deed, you aren't left having to deal with it the way you would with a quitclaim deed. Even when purchasing a warranty deed, sometimes buyers purchase title insurance. This makes sure that if you purchase property without a clean title and the seller lacks the resources to clear title, the insurance company can do so. This is like if you have car insurance and someone else crashes into you. Theoretically, their insurance should pay you for your injuries, or they should pay out of pocket. But if they are uninsured and have no money, you would expect your insurance to take care of you. How deeds work. When property is transferred via deed, that deed must include several things. As you surely recall, under the statute of frauds, a contract for real property is required to be in writing. You need to know what type of deed it is. Is it a quitclaim deed or a warranty deed? Are there encumbrances or other non-possessory interests you need to worry about? The next thing the deed will have is the price the property is being transferred for. It is uncommon for the actual price to be recorded on the deed. Most of the time, it will say something like, for $20 and other valuable consideration. As you recall from contracts, consideration is something of legal value. It just so happens that the valuable consideration in the deed is likely just $20 and, a few $100,000 more. The deed will need to provide a description of the property itself. The description will likely include more than the street address. The property description will be extremely detailed and may include things like township descriptions or the type of description you would see a surveyor use. Once a deed has changed hands, it needs to be recorded with the county where the property is located. The county recorder's office establishes the chain of custody of property. While places are digitizing this information and making it easier to track, many places still have this recorded in old books and sometimes even microfiche. This chain of custody can be incredibly difficult to track and is one of the reasons why it is important to purchase title insurance. Fixtures. When transferring real property, it is a good idea to determine what personal property is going to be transferred along with the real property. Fixtures are the personal property that is considered attached or fixed to the real property. There's a lot of ambiguity about what is and is not considered a fixture, so the best practice is to make clear when transferring real property what personal property is going to go with it. Things like toilets, water heaters, and garbage disposals are clearly fixtures, but a heavy safe, a washer and dryer, or a refrigerator can be considered questionable. The more securely attached something is, the more likely it is to be considered a fixture. Something you can unplug and walk off with is less likely to be considered a fixture. The more important or necessary for an area to function properly, the more likely it is to be considered a fixture. A bathtub is caulked into a restroom, so it's very securely attached, and most people would expect it to stay. A restroom with the bathtub removed is not serving its full function, so the tub is likely to be considered a fixture. But the magic word here is likely. Avoiding ambiguity and spelling out exactly what property is expected to be transferred is much better than trying to argue to a judge later on in court. Landlord-tenant law. A leasehold is another possessory interest and a restriction on ownership for the owner of the property, the landlord. A tenant can possess the property he's rented, but he doesn't own the property. The landlord has title to the property. He owns the property, but he cannot do whatever he wants with the property because the tenant lives there. Each party owes the other various duties that will be discussed shortly. Types of tenancies. There are multiple different ways tenants may occupy property. Each one affects how secure the tenant's possession of the property is. Since a lease is an encumbrance on the property, any transfer of property by the landlord transfers the encumbrance the same way as if it were an easement or other restrictive covenant. If a landlord sells property while a tenant is still legally occupying the property, the new owner has purchased property with the lease terms intact. They cannot simply evict the tenant under the guise that their name is not the one on the original lease. State statutes vary, but most state law looks substantially like the following. Tenancy for a term or periodic tenancy. A periodic tenancy is the most common leasehold relationship. A tenant rents property for a set period of time, most often a year, but any period can be agreed upon. Most periodic tenancies exist with the expectation that the period can be renewed. This differs from a tenancy for a term only in that a tenancy for a term has a set beginning and ending date. The tenant who has not actively renewed their periodic tenancy is considered to have done so, and a new period begins. In a tenancy for a term, the tenant is expected to have moved out by the end of the term. Tenancy at will. In a tenancy at will, there is no set period for the tenancy. The landlord or tenant can end the relationship with a reasonable amount of notice. The tenancy lasts only so long as both parties are satisfied. Most state statutes set what that notice period must be, but in most cases it will be 1 month. The reasonable amount of notice may vary on several factors, though, such as how long the parties have been in this relationship and how difficult it will be for the tenant to move out. For example, if a person has been paying rent monthly in a tenancy at will for 20 years and has accumulated vast amounts of personal property, a reasonable person might expect a longer notice period than if it is a small rental that a person has stayed at for 5 months. Tenancy at sufferance. A tenancy at sufferance is one where the tenant is possessing the property against the will of the landlord. A tenancy at sufferance usually occurs when the period of their lease has lapsed and the tenant has not moved out. A tenancy at sufferance may also be a situation where rent has not been paid or some other lease terms have been violated. A landlord's rights to evict or deny access to the property in this case varies by state law. The landlord's duties to the tenant. The landlord may own the property, but that does not grant her the ability to just do whatever she wants with it. A lease is a restriction on the landlord's ownership ability the same way an easement would be. The landlord owes the tenant some duties. These are the implied warranty of possession, quiet enjoyment, and of habitability. The implied warranty of possession means that the tenant is permitted to live there and possess the property. The landlord cannot tell the tenant to move out, deny them the keys, move their personal property that is situated in the property, or otherwise take away from their ability to physically possess and live in the property. The implied warranty of quiet enjoyment means that the landlord cannot harass the tenant and also has a duty to attempt to keep others from affecting the tenant's ability to live peacefully in the property. The landlord cannot simply unlock your door and come into your property whenever she chooses. She must notify you within a reasonable period of time to let you know she needs to enter the property, and can only do so if there is a reasonable need, like to do maintenance. If you're in a duplex and your neighbor is blasting music at 2 a.m. or blowing smoke onto your rental, the landlord must rein them in to ensure you can live peacefully. Finally, the implied warranty of habitability means that the landlord has a duty to ensure the property is properly maintained and is suitable to live in. If there's a broken pipe, it must be repaired to ensure clean water comes in and sewage flushes out. If the furnace breaks in the winter, it must be quickly fixed. If a window is broken or the ceiling leaks, it must be fixed within a reasonable period of time. In short, the rental must be habitable. It must be a safe and secure shelter to live in. The tenant's duties to the landlord. The landlord, having honored their duties to the tenant, is owed certain duties in return. A failure to perform these duties by the tenant may result in an eviction or other damages as the court may direct. The main duties owed by the tenant are the duty to pay rent and the duty not to commit waste. As anyone would expect, a tenant must pay their rent in a timely manner. Unless a lease agreement says otherwise, in most cases the obligation to pay rent is joint and several. Recall the material on general partnerships. If the partnership is sued, the court judgment may be required to be split unequally if the parties have varying levels of assets. So too with rent. It is common for several people to lease a property together and pay rent equally. If one of those people were to suddenly leave, the remaining renters must make up for the rent paid by the lost renter. If they fail to do so, they may all be evicted. It is no excuse to tell the landlord that someone left. The full amount of rent must be paid in any configuration if everyone wants to remain in the property. It is possible for the remaining renters to sue the person who left. but this does not relieve them of their obligation to the landlord herself. Tenants also have a duty not to commit waste. They must make a reasonable effort to take care of the property. This does not mean that the tenant has to go out of their way to improve the property. It just means they cannot damage or neglect the property. It is expected that I mow the lawn and do not let the yard grow out of control. I should also give it sufficient water so the grass doesn't die. I cannot go randomly digging holes in the yard or pour waste oil down the drain. I cannot allow pets to pee in the house. I cannot go punching holes in the wall. So put down the Monster Energy, Kyle. No one's impressed. It's just drywall. I can't use the living room as a mechanic's shop. Normal wear and tear is expected and accepted, but I cannot neglect the property and act as though I do not care just because I'm not the title holder. Remedies to problems in the landlord-tenant relationship. There are several possible remedies when either the landlord or the tenant fails to meet their duties to each other or are otherwise dissatisfied with their relationship. We'll discuss each of them here. It's important to understand that at the root of the conflict between landlords and tenants is a contract dispute. A lease is simply a contract, and many other terms of contract law intersect alongside property law. Just like with a breach of contract, the parties will have a duty to mitigate. If a tenant leaves 2 months into a year-long lease, the landlord cannot simply smile and rack up damages for the remaining 10 months unless they are actively trying to limit their damages by seeking out a new renter. A renter who can resolve a problem quickly and cheaply should do so rather than allow damage to accrue. If a pipe breaks and you can just place a bucket under the leak or turn off the water, then you should do so rather than allow your personal property and the landlord's real property to continue to suffer unnecessary, unavoidable damage. State statutes vary on the below remedies, and many states also have special rules of procedure that guide landlord-tenant law. In many jurisdictions, a trial to evict a tenant for non-payment of rent can be had much more quickly than most other sorts of civil trials. However, additional notice periods and other requirements are often needed as well. Eviction. Evictions are the most common thing a landlord can do when the renter is not upholding their duties. Most commonly, evictions occur due to the tenant not paying rent, but it can come from other actions as well, such as damaging the property, criminal behavior on the property, or violating the peace of their neighbors. Alternatively, a tenant may argue that they've been subject to a constructive eviction. A constructive eviction is when the landlord hasn't really evicted them, but they have either made the property so unlivable, generally by violating their implied warranty of quiet enjoyment, or the property has become unsafe. An example of this would be if water or sewer lines broke and the landlord has failed to repair the problem in a reasonable time, violating the implied warranty of habitability. With a constructive eviction, if the landlord does not solve the problem, a tenant might abandon the property or sue, requesting a termination of the lease in their prayer for relief. Rent abatement. In some cases, if the landlord has failed to provide what was agreed upon in the lease, the tenant might seek a rent abatement where the tenant stays in the property for a reduced rent. Alternatively, the parties might agree to have the tenant repair the property themselves and deduct the cost of the repairs from their rent payment. Be cautious and attempt to work with your landlord as best you can in these sorts of situations. If you refuse to pay rent, abandon the property, or reduce rent based on your own determination that you're entitled for compensation for repairs or some other defect, you may find yourself having to prove this in court if the landlord seeks to have you evicted or to recover full rent. It would be unfortunate to spend money to repair property only to have the landlord recover full rent or to reduce your deposit and put you in a position to have to sue to recover after you move out. Assignments and subletting. If the tenant is unable or unwilling to complete their lease, they may seek to have another possess the property. This is frequently done either by assignment or subletting. With an assignment, the lease is completely taken over by the new renter. The previous renter is completely released from the lease and has no responsibility for rent or any other matter moving forward. Sometimes the tenant doesn't want or cannot get completely out of the lease, but wants to permit another to rent the premises for a period. Imagine a year-long periodic tenancy while you were in college. During the summer, you wish to go home and spend time with your family. You might seek to let someone stay in your apartment during the summer months. In this case, the renter will permit the third party to rent the property. The original tenant is still responsible for paying rent to the landlord, but the third party, called the subtenant, will owe rent to the original tenant now called the subletter. It is important to consider exactly what the lease says. Many leases have provisions to disallow assigning or subletting property without the landlord's express agreement. Oftentimes, people seek to abandon the property and argue that they found someone to take over the lease. The landlord is not required to accept just anyone, but courts will sometimes require that they accept reasonable tenants, capable of passing background checks and have gone through the appropriate process a regular tenant would have gone through.